I may proceed?
Yes, counsel.
Good morning, and may it please the court. My name is Elizabeth Rodriguez, and I would like to, Elizabeth Rodriguez for petitioner, and I would like to reserve 3 minutes for rebuttal. First, I will focus on whether there was an error in the finding by the lower courts to establish that petitioner, did not establish prima facie eligibility.
Could you speak a little more into the mic, please?
Oh, sure.
Yes, thank you.
I will focus on the lower court's finding that there was not prima facie eligibility for hardship for the motion to reopen. First, the standard...
Well, there's no lower court here, is there?
Oh, excuse me, the BIA.
Okay.
The BIA's finding, excuse me. The prima facie ground is reasonable likelihood, which requires more than a mere possibility, but less than a showing that it is more likely than not that the petitioner will prevail. In this case, we do argue that he did establish that by showing that he had the qualifying relatives, and we further argue that the hardship, as this court has also found, is both a legal question and a factual one. So we are arguing that the appropriate action would have been to remand the case to the immigration judge to be able to follow through with that.
I'm sorry, I don't understand. He showed that he had a qualifying relative, but not anything about that relative's hardship.
Yes, he did not specify that there was any hardship. However, we are arguing that there was an existence of the qualifying relatives and that he was able to show all the other factors, for example, the 10 years of physical presence here in the United States, and then also good moral character, and that the next obvious question is...
Does your contention turn in any way on what the standard of review is with regard, or what the requirement is with regard to a showing of a prima facie case, whether it's a likelihood or what it is?
Yes, so what we are saying is that the plain showing that there was qualifying relatives should have been enough, and that the rest would have been a factual finding that could only be really determined if it were to be sent back to the immigration judge. So that's essentially our argument.
Do you have any case law supporting your view that merely showing that they're qualifying relatives without more is enough to meet the prima facie burden?
Well, the only case is the one that we did cite, which is Fonseca. And again, so it just shows a mere possibility, or that's the standard, that a mere possibility should be sufficient.
No case is fine. Is the standard? Have you demonstrated that by showing nothing about the hardship to the children?
I don't know that we have, to be completely honest, but we're essentially arguing that it should have been sent back so that that determination could completely be made at that point, since the hardship is truly mostly a factual analysis.
You want to discuss the Fourth Amendment question at all?
Yes, that was my next point. So here it's whether there was an egregious violation, and obviously, it is important to look at the facts in this case. Here, the petitioner was stopped while he was on the side of the road because he was lost, or at least that's what he stated in his declaration.
Could I just interrupt there? So does the Fourth Amendment argument depend on your prevailing on the I-213 argument as well? In other words, the allegations as to the Fourth Amendment are contained in the I-213?
No, not necessarily. I think it's important to also look at the petitioner's declaration. Mm-hmm. What's important there is that, and I don't believe it actually states this in the I-213, so there is a conflict there, obviously. He, in his declaration, states that there was another car also parked right near him, yet he was the one targeted. As far as I can recall right now, I don't believe that was even discussed in the I-213. So our argument is that, at minimum, he should have had also the opportunity to cross-examine the officer who created the I-213, specifically because there was obvious conflict in what he was saying in his declaration and what was actually in the I-213.
And what was in the I-213 that's relevant to the either reasonable suspicion question?
Really, the only thing that is specified there in the I-213 is that the officer saw the individual parked and he decided to go and speak to him. And I do know that opposing counsel or respondents here are arguing that because of that it was a consensual interaction. However,
but actually in the briefs, the briefs here, the government's argument is not that it was consensual, but that there was reasonable suspicion.
well, that's part of it, but in the briefs, the respondents
But
do...
that's in your favor in the sense that they don't seem to be standing on this consensual encounter language.
Right, yes. So I guess our argument is both there was no reasonable suspicion and then also that it was not consensual at all. This is not a case where, like in Mendenhall, for example, the person did not just walk in with an officer into the DEA offices. This was somebody who was stopped on the side of the road. There was really no other options for him other than speak to this officer who was armed. I mean, the only other option for him would have been to keep driving, and then, of course, then there would have been reasonable suspicion for this officer because then he would have fled, and then, obviously that is suspicious. So, yes, and then if you have any more questions.
So if we do have rather loose standards as to what's consensual in the sense that although many people would think that if an armed officer comes up to them, they don't have any choice, that doesn't seem to be the case law.
I think in this case, it is important to look at how the officer comes forth, and that is in the case law. Obviously, if the officer's aggressive or whatnot, then that would be important.
We have no evidence of that.
Yes, we would concede to that. There's no evidence
All
of
we
that.
know is that an armed officer came up to him when he was already stopped, so he didn't actually stop him, and asked him some questions.
Asked him some questions, asked for his ID. The petitioner saw no option but to give him his ID, seeing that the officer was armed. And again, his only other option were to just be to drive away. In any traffic stop, I don't think that really is an option. He obviously wouldn't want to put the officer in any type of apprehension that he's in danger. I think we all know that if an officer stops us, we want to keep our hands on the wheel and we want to be respectful.
Well, in this case, he was already stopped, so it wasn't a traffic stop. And I think, while I understand it may seem like there's not really any other option, I think technically he could have just said no, right?
In theory, yes, Your Honor. However, again, we do want to look at the other part of this case, which is why was he specifically targeted and not the other vehicle who he said was right in front of him? Why was he targeted? And there's really nothing showing why that would be other than, in this case, potentially appearance.
And I don't know the answer to this. Would that matter, supposing there wasn't, in fact, a seizure, but nonetheless he went and asked him questions and not the other person? Would that be a problem? It wouldn't be a Fourth Amendment problem, right?
Well, then it would be equal, I would say, but that wasn't the case here. Our argument is that he was specifically targeted and the other person was not.
He was targeted, but was he seized? That's the question.
I think when looking at this how he felt and subjectively and seeing an officer coming at him and not being able to really drive away, if you look at it that way, it could potentially be a seizure. And I think I'm actually finished with my argument unless Your Honors have more questions.
No, you can reserve your remaining time for rebuttal.
Thank you.
Good morning. May it please the court. My name is Jennifer Singer, and I represent the United States Attorney General, the respondent in this matter. I was going to start with the Fourth Amendment issue, but since opposing counsel started with the motion to reopen, I'll just start with that. And it appears that petitioner's counsel conceded that there was no evidence of hardship presented on the motion to
Can I ask a
reopen.
question just a minute on the time? You seem to have started at 10 minutes and she started at 15 minutes.
Thank you, I did not notice that. It appears that petitioner concedes that they did not submit evidence of hardship with the motion to reopen. And by failing to do so, they failed to establish a prima facie case of eligibility for cancellation of removal. So for that reason, given the fact that there was no evidence on that one issue, the board did not abuse its discretion in denying the motion.
What is your
to reopen.
understanding of the standard for a prima facie case?
On the motion to reopen context, on Fonseca, a reasonable likelihood that the statutory requirements, in this case, cancellation of removal, were met. And if there's no evidence on one of the prongs of a statutory requirement, in this case hardship, it's impossible to meet the prima facie standard.
And in the Ninth Circuit, what's the standard review when we're reviewing that reasonable likelihood decision?
In the context of a motion to reopen, it's abuse of discretion. But I guess with the Wilkinson decision, it's a little bit unclear as to what the underlying facts are. But again, here, it's not an issue of fact-finding here. It's an issue of the presence or absence of evidence.
Right.
So I still would...
Well, it would never be a fact-finding, would it? Because it would always be based on, it would be like a summary judgment standard or a motion to dismiss standard, essentially.
I mean,
It would always be, there'd be no fact-finding by the agency because there would be nothing except declarations at most before it.
I mean, and yes, technically that's correct. But the board does have to look at evidence and see if it's sufficient to meet the prima facie standard. So I guess to one extent it accepts as true the evidence submitted to see if it does meet the prima facie standard. But again, here, this is more an issue of absence or presence of evidence, and under the abuse of discretion standard of review, the absence of evidence just did not meet the prima facie standard.
And what about the Fourth Amendment?
So that's with the Fourth Amendment. I would like to note that in our briefs, we did argue that the encounter was consensual.
Right.
I did argue the reasonable suspicion because petitioner's counsel argues that he was detained right off the bat.
But it couldn't, well, just to start with the reasonable suspicion, the suspicion was what? That he was sitting there on the side of the road and he looked.
Why don't we take a short recess and we can resume?
It might be longer.
Okay, well, why don't we take a recess and then we'll confer.
All rise. This court now resumes its session. Please be seated.
Thank you, everyone, for your patience. Prior case is submitted.